Welcome to Case by Case. This is a podcast series put together by Luke Sadkovich and Calum of Zyla Floyd Sadkovich, in which we, as the name suggests, look at legal cases on a case-by-case basis, seeing what's of interest in them, looking at recent cases and developments that our clients, contacts, friends, colleagues might be interested in. Calum and I, we haven't spoken about the case we're going to talk about today, albeit we know this area very well. I think it's fair to say near and dear to our hearts, having been involved in many alter ego Rule B cases over the years. But we don't talk about it beforehand. We each read the decision, jump onto the podcast, hit record, and see what each of us made of it. Calum, welcome.
Thank you, Luke. Looking forward to this one. As you say, Rule B, alter ego attachments, something that we've seen a lot of, so it's good to have a case that falls right into that sweet spot. And also good to do one from the other side of the pond. This is a US case, so something a little bit new to me. Been involved in a number of US cases, obviously, but it's my involvement on the US cases usually doesn't have me reading the case law in great detail. So this was an interesting break from the English cases.
Yeah, good stuff. Yeah, so for listeners, Calum's an English solicitor. I'm also an English solicitor, but I'm also qualified in New York, in the US, and in Australia. So we like to keep abreast of what's happening on both sides of the pond, so to speak. And we're often actually involved in cases that throw to both sides. And Calum and I have worked on a number of cases where we've had a Rule B or some type of attachment security proceeding happening out in the US, and Calum and the English team, myself, will be working on the English matters as well. So especially when there's like an underlying charter party or bill of lading or some other type of maritime contract underpinning the security action that's subject to English law. So quite common that they throw to both jurisdictions, and something we see quite a bit of.
Yeah, and it seems as though the US generally is a reasonably good jurisdiction for a party to seek security. That might be oversimplifying. It might be a bit of a broad statement, but it seems like it happens quite often that we'll have a case in arbitration in London, LMAA, LCIA, and we'll look to the US to see if there is anywhere that we can find security, partly because the US is obviously central to trading, so the physical assets are not infrequently within US territory, but also because the legal framework in the United States, or in some of the circuits in the United States, seems to be reasonably favourable to a party seeking to attach security, to attach assets for security.
It's a good point, very good point, Calum, and it's probably worth making it now at the opening that there are distinct differences between the English approach to lifting the corporate veil and arguing that different corporate entities within a group one and the same thing, to doing that in the United States, which has a different test, different basis upon which to do that. And then within the United States, there are different thresholds, different tests for alter ego liability, as it's known there, lifting the corporate veil, and those types of actions. And we'll get into that a bit. It's useful at the outset to say that this case that we're dealing with today, it's a recent case. It's a March 2021 decision, and the main parties involved are Pacific Gulf Shipping and their insurer, Michael Else and Company. And then on the other side, the defendants are Vigorous Shipping and Trading, Blue Wall Shipping, and other companies related to, or alleged to be related to, Adamastos Shipping and Trading. It was a Ninth Circuit appellant decision, so this went up to the United States Court of Appeals in the Ninth Circuit, sitting in Oregon. The Ninth Circuit, for those of you who are not aware, is really the west coast of the US. So you've got California, Alaska, Arizona, Hawaii, Washington State, Oregon, and some others that are in the Ninth Circuit. So this appellant decision relates to that circuit that covers those different US states. There are other circuits within the US that apply a slightly different test, and we'll unpack that a little bit as we get on. Well, before we get on to the legal principles, Calum, is it worth just giving a quick recap of the facts of this one?
Yeah, let's do that, because again, as I tend to say at the start of these when I go through the facts, the fact pattern is not particularly uncommon. It's something that we see reasonably frequently. So let's go through it and take it kind of step by step. The first thing to note is that this claim is kind of ancillary to main proceedings, which had already concluded at the point that these proceedings started, and fundamentally there was a dispute between a party called Adamastos, which was a special purpose vehicle who owned a vessel which was called the Adamastos, which was operated by a company called Phoenix Shipping. Adamastos had chartered the vessel out to Pacific Gulf, who had onward chartered it to a company called Intergis, who had onward chartered it to Marubeni, and there were a number of problems with this vessel. An engineer who visited the vessel noted over 40 defects, I think, at one stage. Ultimately, the vessel ran aground in Brazil and it was promptly abandoned by owners. The insurance was cancelled, and liability for a huge amount of cargo damage kind of found its way up the claim, up to Pacific Gulf, the head time charterer, who then wanted to essentially recoup some of that money against Adamastos. So they brought the claim against Adamastos in arbitration. They succeeded, and they had the benefit of an arbitration award against Adamastos, but there was no money in that entity. So we're in this relatively frequent situation that we see in the world of international trade, where there's a special purpose vehicle company which owns an asset, which is a vessel, and doesn't own anything else, but is part of a group structure that owns a number of different vessels. In this case, the ultimate owners seem to be the Gordo Michaelis brothers, who owned Phoenix Shipping. It wasn't actually mentioned in this judgment specifically, but it appears that they are essentially the ultimate beneficial owners in Adamastos, that SPV. And they also separately owned a company called Blue Wool. And Blue Wool then owned 8 different SPV ownership entities, one of which is Vigorous Shipping and Trading. And Vigorous Shipping and Trading in turn owns a vessel called Vigorous. And the vessel Vigorous was attached by Pacific Gulf in support of, or in an attempt to enforce their arbitration award against Adamastos. So you get into this question of, are Pacific Gulf entitled to arrest, to attach the Vigorous vessel in order to enforce their claim against the Adamastos company?
Yeah, exactly, and it's one of those cases we tend to see quite regularly. Not the exact facts, but facts quite similar to that, where you may find that in the maritime context at least, and it's not necessarily limited to maritime context, but where there's a group structure that's been put in place to separate different vehicles with SPVs and then separate management of those SPVs, attempts to separate ownership. But then what happens in practice does not necessarily follow that structure. And if you're on the side of looking to enforce an award, as it was in this case, or indeed to get pre-proceedings, pre-arbitration security, then you might try to look not just at the individual entity that you have the claim against or the award against, but also those companies related to them. And we get involved in many of these cases from an investigative perspective, first sizing up how companies are structured and how they operate, to either make the attachment and bring the attachments, or indeed to defend them if they're brought against our clients. So it's something we know very well. We get involved in them all over the US, and so we've come to learn the different tests in the various circuits quite well. And from a procedural perspective, just to give some intro into how this works, what's happened is that the plaintiffs have brought the attachment proceedings against the defendants arresting the ship while it's in the jurisdiction. Security was posted while challenges to the attachment were heard. The moving parties, so the parties that are defending the attachment, they have filed motions to dismiss and motions for summary judgment, essentially alleging that the allegations of alter ego, the allegations of successor liability that the attaching party had made were not sufficiently made out, and they would have filed those motions at a threshold level immediately or shortly after being served with the papers. And then the first test, if you like, that the attaching party needs to get over is whether there's enough of a factual allegation here to support the legal pleadings to get into jurisdictional discovery. And that is where the party who's on the receiving end of the attachment has to discover relevant documentation that goes to the allegations that are being made about alter ego, and in this case, successor liability. And then after that period of discovery, I think there were 12 depositions taken and over 100,000 pages of documents discovered in the jurisdictional discovery in this case. The parties then have an opportunity to put in briefing papers and to argue that the evidence that has come out through discovery that supports the allegations, or as eventually turned out to be the case in this one, there wasn't sufficient evidence, according to the first instance judge and then upheld on appeal by Circuit Judge Boggs, that there just simply wasn't sufficient evidence through the jurisdictional discovery process to maintain the attachment.
So if we step back, the basis for this attachment is essentially that the ownership of these two vessels, the vessel that caused the damage originally, or the company that owned the vessel that caused the damage originally, the company against whom Pacific Gulf had the claim, is the same company in effect, if not in legal structure, to the company that owns the vessel that was attached. Is it fair to say that's essentially what charters or not charters, Pacific Gulf are trying to show here? That's, if we strip back again, away from all of the legal questions, that's really what they're trying to demonstrate to the court, is that this is the same entity and they owe us in respect of a debt owed to us by the company against whom we have the arbitration award.
Yes, I think, think Spider-Man or Batman or something like that, where you've got an alter ego. It's one of the same person dressed up in some underpants on the outside, exactly, or something like that.
Take off the cloak to reveal a cargo ship.
Scrub off the name of the side. Well, usually the name of the vessel on the side sometimes comes into these alter ego claims. Anyway, I digress. But that's what we're talking about. We're talking about alter ego, meaning two entities that are effectively one and the same thing, even though they're set up separately. There was an additional allegation in this case, which is not seen all that often, but that's of successor liability. And that was kind of given quite short shrift, I thought, by the court. And that's where one company is closed down and transfers all its assets over to a Phoenix, pardon the pun in this case, but a new Phoenix-like company that rises from the ashes and lo and behold, has all the assets of the other company that was wound down. And I don't think we need to get into the details too much of the successor liability element, but effectively what the court said here was that there needs to be a transfer of assets for successor liability, and they just didn't have any demonstration of that at all. The court found that was a prerequisite for successor liability. So I think we'll spend most of our time talking about alter ego and the alter ego allegations.
So looking at the alter ego allegations, there are tests and standards that a party has to meet if it wants to get home on this alter ego allegation. And something that is discussed in this judgment that I know we've discussed before in the context of different jurisdictions is the conjunctive standard versus the disjunctive standard. And I think that's something which is worth discussing as we go through the different things that you have to satisfy in order to persuade the court that you're dealing with an alter ego.
Yeah, and it's critical to understanding how the different circuits work within the US to keep it at a very high level without getting into too much detail and losing our listeners perhaps. In New York and neighbouring states in the second district, they apply a disjunctive test, whereas the Fifth Circuit down in the Gulf of the US and the Ninth Circuit out in the West and others apply a conjunctive standard. And what we mean by that is there are elements to the alter ego test in the different circuits. And when we say a disjunctive test, what we mean is you need to show one element or the other element. And if you show either of those elements, you're home. You've succeeded on the allegation. Whereas when we talk about the conjunctive standard, you need to satisfy all the limbs of the test. And that is elevating or heightening the threshold upon which an attaching party can successfully obtain an alter ego claim.
Yeah. And the tests themselves are not particularly easily met because there's nothing wrong legally with the concept of group ownership or wholly owned subsidiaries. So the idea of piercing the corporate veil, particularly from an English law standpoint, is not something that the court is going to do easily. They have to really be persuaded that the party who is seeking this alter ego attachment has a good basis to say that it's more than a normal, completely legal situation of group ownership or a wholly owned subsidiary. What we're looking for goes beyond that, and I think that came across quite clearly in this judgment because the judge, as you say, the judge gave quite short shrift to a number of arguments, but one of them was the fact that there was something inherently wrong with effectively this type of structure.
Exactly, and so if I may just touch on the test in the Ninth Circuit. So the test for alter ego liability in the Ninth Circuit, in the circuit in which this Pacific Gulf and Vigorous decision was decided. And there's three elements to this test. And I am paraphrasing here, so obviously if you're looking at this in detail, please do refer to the judgments. But the first element is total domination of the subservient corporation. So, no kind of separate corporate interests, this concept of total domination. And we also see reference to control, domination and control of a parent with a subsidiary. So that's kind of the first limb. The second limb is that there would be injustice that would result from recognising the separate entity. So if it will bring about injustice that we now say that these two entities should be considered separate rather than as one and the same, and that's how they've been holding themselves out and not operating. If it's going to bring some kind of injustice, then that's the second limb that needs to be satisfied. And so this is the conjunctive test. So 1, 2, and 3. The third one is that the controlling entity had fraudulent intent or an intent to circumvent statutory or contractual obligations. And this, for me, is really the critical element here, this concept of fraudulent intent or intent to circumvent. Anyone who's got some understanding of criminal law or has watched Law and Order over the years and knows what mens rea means, once you start talking about intent and what someone subjectively intended to do, you're looking at a higher threshold. And so it's those three elements that need to be satisfied in the Ninth Circuit.
And to me, the injustice element is probably the easiest of the three, because there does seem to be an injustice in a situation where an injustice in a very sort of general, almost moral way of looking at it in a situation where there is a whole stash of money and a whole stash of assets within the same ownership, but a party can't access those assets despite being liable to one of the group companies because of the corporate structure that's been set up. That seems to me to be perhaps the cleanest of the three, and it's the other two that are really quite difficult to distinguish between normal, like I say, normal group ownership and something which is wrong, and particularly where you have that layer of finding some kind of fraudulent conduct. Essentially, this system being set up, specifically to deprive creditors of a recovery, is a difficult thing to evidence and a difficult thing to show.
And that is closer to the English type of test for lifting the corporate veil, that there's some fraud involved in the cloak, in the veil itself, some sham that was set up from the outset. So anyway, I won't go into the English test right now. I'm keen to kind of unpack, though, the differences between the circuits in the US. And I find it quite interesting, Calum, you've picked up on the second limb and the injustice limb as being probably the easiest of the three to demonstrate, because if we think about the Fifth Circuit test, and you and I, we've dealt with this quite a lot in another case, which we'll come on to mentioning in Texas, the FinBank decision. In that case, which was at first instance, it didn't go up to the Court of Appeals, but in that case, it was explained that the test in the Fifth Circuit is there's only kind of two limbs to it, although I think it's almost similar to the Ninth Circuit test, and that is abuse. So the first point was abuse of corporate form. So again, going back to this concept of domination, control, abuse, using the corporate form in ways that it's not intended to be used. And then the second part, and there's only two parts in the Fifth Circuit, is that this abuse of the corporate form promoted a fraud or injustice that injured the plaintiff. And it's this concept of wrongdoing or some type of wrongful conduct. It's not, while fraud is used in the description I've just given, it's not necessary to demonstrate a fraud in the strict legal sense of that word. It could be some kind of injustice or wrongdoing or wrongfulness in another way. But there's not this separate, it's not described as an intent, and there's not this separate injustice. It's almost like the injustice limb from the Ninth Circuit and the intent limb from the Ninth Circuit have kind of been bundled up into one in the Fifth Circuit without the strictness of the intent requirement. So I thought that's really interesting.
Which makes a bit of sense to me. I mean, that makes a bit of sense to me. It's hard to think of a situation where somebody would be going to the court asking for relief in a situation where there had been this kind of dominion and control over a subservient company with ill intent and some kind of fraudulent design, but there was no injustice. It's hard to think of a situation where that injustice limb would be in isolation the limb that was not satisfied. If you have the other two and you're asking for some kind of relief from the court, you've probably been exposed to an injustice somewhere along the line.
Yeah, exactly. And I thought this line was quite a good one. Just summing this up in one sentence. This is from Circuit Judge Boggs. The Ninth Circuit has a conjunctive test. There must be domination and control and injustice from not piercing the veil and some form of ill intent. And just focusing on those last 5 words there, some form of ill intent. That's not as high as saying it has to be a fraudulent intent, or it has to satisfy the concepts of strict fraud as we know them. It's some form of ill intent, and there's also reference to the bad intent requirement elsewhere in this decision. So I do think that somewhat equates with the concept of wrongfulness and injustice that we see mentioned in the Fifth Circuit, and that even in the Ninth Circuit, whilst there is definitely an element of intent there as a part of the test, it can be I think it's arguable, some form of wrongdoing that can satisfy that.
So perhaps using Finbank as an example, or perhaps using, I know this is mentioned, the different kind of indicating things that you might look for if you're trying to pierce the corporate veil was mentioned in this judgment as well. But in practical terms, what sort of things are you looking for to show that this is not simply a wholly owned subsidiary? This is something which goes beyond and it falls into this concept of abuse of the corporate form in the Fifth Circuit, or dominion and control in the Ninth Circuit. What are the kind of things that we look for when we do this investigative work?
Yeah, so there's a long list of indicia that you can refer to, rely upon in trying to make out alter ego allegations, and no one factor is decisive. No combination of factors is decisive. It's really taken in the round. And so that those are factors like disregarding corporate formalities, inadequate capitalisation, common ownership, use of shared telephones, contact details, offices, not dealing at arm's length between companies, using one company as a treasury account for multiple other companies, some companies not having bank accounts and using the bank accounts of others in the group, common management control, overbearing control, avoidance of kind of corporate form between shareholders and management. There's a long kind of list. Cross company guarantees is another one that comes to mind, and there are others. But it's kind of, there's a list of factors that are mentioned in the decisions on alter ego and that we rely upon. But you also like to see, or if you're trying to make out these allegations, you also are trying to look for some element of, untowardness, if that's a word, or wrongfulness, where it's not just a convoluted corporate structure, but there's been some benefit that structure has yielded in shielding itself from liabilities and from other creditors. So you might look for things like patterns of not paying old debts, or creditors chasing them, or fancy footwork around closing a company and opening up another company. Things like that, whilst they may not necessarily go to the specific intent or wrongful limb that you need in the Ninth Circuit or in the Fifth Circuit. But if you're just looking at the domination and control factors, which is what we're talking about now, then you still would like to see some elements of wrongfulness in there, or some deceit of some kind.
And I think it's not only, at least in my experience, it's not only that they're trying to avoid debts or they're trying to avoid making payments. It can also be that they're trying to induce further business. So the group company holding itself out as having this massive fleet, for example. We own all these vessels. We're a great credit risk. If you want to enter into business with us, then we have all these different vessels. And then when you lift the bonnet, you find out that actually that company owns none of those vessels, but you've been induced into entering into a contract with them. For example, it's quite. My experience looking at these things, at least, has always been it's quite broad the way that you look at it at the start, and you kind of evaluate the entirety of the target entity and the target group entity, and then you start to see if there are any patterns showing up, if there are any things that stick out as kind of jar against the idea that each of these entities are their own companies.
Yeah.
And kind of see what you can find. And essentially, you're almost looking for some degree of human error somewhere along the way. People have forgotten to keep things as tidy as perhaps they ought to have done, or they've overstated what one entity can do in isolation. Is sometimes enough, rather than necessarily, looking for something where it's perhaps a more clearly fraudulent piece of conduct, like trying to avoid paying somebody for something.
Yeah, I see that. And the point you're making there, I think, is a good one, but it's important to conceptually at least think about, are you talking about the domination and control limb, or are you talking about the wrongfulness limb, if I can call it that, or the two limbs there are in the Ninth Circuit? And this is coming back to the conjunctive test and disjunctive test, because in New York, such a important jurisdiction in the US, in the Second Circuit, in which that state is, you can get by with alter ego on just satisfying the domination and control limb. You don't need the wrongfulness limb as well. That's the disjunctive standard. You can have wrongfulness without domination and control, and that's enough as well. But when we're talking about the Ninth Circuit, which has this three-step test, as we've explained, or in the southern states with the Fifth Circuit, and I should say some of these tests are still up for debate. There are debates to be had in the context of on every case, and it was even argued in this decision, what is the actual appropriate test. So there are discussions and arguments to be had on the limits of these tests in the various states. But just looking at it from a broad commentary type perspective, in the Fifth Circuit, you've got the conjunctive standard. So you need to satisfy domination and control, and you need to have this wrongfulness element too. So what you're referring to, as an example of where in, say, the contract negotiations and at the time of contract formation, one party is holding themselves out to have this big group company, and that's relied upon. That is a factor that could go towards the domination control argument, I suppose. But I see that, and we've used it in this way as well, I see that also as a wrongfulness argument. If there's been a misrepresentation or some error, misdirection on the size of this company, and a party's been led into a contract thinking that they are contracting with a big group, and there are lots of vessels and assets in that group to go after if something goes wrong, then I think that could go towards the wrongfulness type argument as well. There'd be debates about that depending on the circuit. Ninth Circuit has this ill intent, so you've got the subjective element coming into it again. There'd be debates around whether that's enough, but I'd like to make that point because the way that the courts look at these tests in the conjunctive states particularly is, okay, well, you might have domination and control, you've got lots of factors, but you don't have anything on wrongfulness. And that's kind of what was decided in the Pacific Gulf decision. It was accepted that there was some common ownership. It was accepted that the the brothers had involvement in the management. There was other issues around the use of bank accounts across the companies, but it just wasn't enough. It didn't go to showing that there was evidence of ill intent, and that's where it really came down. So you'd want to, when you're looking at an attachment in a conjunctive state, you really want to be focusing on that wrongfulness element as well.
Yeah. And like you say, it almost seemed as though the judge went along with them to say, yeah, you've proved things that you've argued, but you haven't properly argued for these other limbs that you have to satisfy here because we have this conjunctive standard that we apply.
Yeah, it was almost as though the case was argued as a New York case, going for domination and control without sufficient consideration of the wrongfulness, the ill intent element here, and that's not. I don't mean that in a critical way, because I anticipate that what the attaching party was hoping for, if I can put it like that, is they had a reasonable basis for putting out the allegations and making these allegations to begin with. They did enough to get into jurisdictional discovery, and as I say, that is a threshold. That's the preliminary threshold to get over. They got into that. There was extensive discovery, documentary and testimonial discovery, and then the evidence just didn't come out that they were no doubt hoping for. And so, you are where you are at the end of the day there. And how did the court describe it? It came away empty-handed from discovery.
Yeah, yeah. They don't. Well, at least in this judgment, the US judge didn't really hold back with some of the plain speaking.
What did you make of, just on that? What did you make of the differences between reading an English judgment and a US judgment?
So
this is an appeal judgment too. Remember, this is a Court of Appeals decision,
and I feel like it's more formulaic on the US side.
Mm.
It felt more. I don't know if I can say cookie cutter, but it felt more as though the judge said, I now consider this, and they deal with it very, very briefly. Whereas on the English side, it feels like there's more. There's slightly more of the judge's thought process before the judge's conclusion in some of the English judgments, and I don't know if that's consistent across different circuits, across different judgments, but that was my impression having read this one. It was a little bit more, this is what I'm considering and this is what my answer is. This is what I'm considering and this is what my answer is. Whereas on the English side, they perhaps weave slightly more yarn to get there.
I think that's fair, and I'd agree with that across different decisions. Perhaps Supreme Court decisions have a bit more of the prose approach to them. But in many of the decisions like this, maritime decisions you see and other commercial decisions, the judge pretty much answers the questions as they're put, in a way. And yeah, just as you've described. So I think that's a fair and reasonable approach. Well, look, I think it's been a good one. As I said at the opening, this is an area that we've done a lot on. We've had a case, well, I've had a couple of cases over last year on alter ego, quite large multi-million-dollar cases, and one in the Fifth Circuit, which had a different outcome to the outcome here, at least in that the district judge gave a decision on jurisdictional discovery that upheld the initial attachment and vacated the motion to dismiss. And I just wanted to finish my points on this case by just touching on that one briefly, Calum.
Yeah.
And the real distinguishing feature between that case, which was a Fifth Circuit case in Texas, and this is an Oregon Ninth Circuit case that we've talked about today, the Pacific case. But for all intents and purposes, they're both conjunctive states. I think this argument would have held in both jurisdictions. But in the FimBank decision, what we relied upon and the judge accepted at a preliminary level. Okay, this wasn't a final decision. This was just following jurisdictional discovery we saw off the motions. So it wasn't a final decision on the point. But what was alleged there that caught the judge's attention was that the SPV that owned the vessel, the asset, and this is the SPV that the attaching party had the claim against, they had disposed of the vessel and it was no longer in the ownership of that SPV. And they did that with full knowledge of the claim. There'd actually been a standstill agreement in place between the parties which had lapsed, and then the asset was moved. And that was enough, that disposal of an asset was at least enough not to finally decide the decision, but to see off a motion to dismiss and allow the case to move forward. And it's a good point for me, because when you're looking at wrongfulness, when you're looking at ill intent, when you're trying to satisfy the other side of the conjunctive standard, not the domination control standard, but the other side, whether it's injustice, ill intent, wrongfulness, you're looking for things like that. You're looking for disposal of assets. You're looking at, as you said, a misrepresentation case. That's another good one. Some clumsiness in there if you're on the side of wanting to make good on an attachment. Yeah,
exactly. It's good fun, actually, the process of trying to build these applications. You feel a bit like a PI going through all the papers and trying to find out, to piece the jigsaw together.
Yeah.
One of the really enjoyable things to do.
Yeah, absolutely. All right then. Well, I think we've rattled on enough about alter ego in the US. I really enjoyed it. It's an area of law I find fascinating, and I actually really enjoy practicing it for those reasons you've just given, Calum. Good to have a chat with you today about it. I hope everyone's enjoyed today's podcast. If you've got any questions, of course, feel free to follow up with Calum or myself. And we've enjoyed having you listening in today. Thank you for your support, and please do continue to follow and subscribe our podcast. Thank you.
Thanks very much, everybody. Goodbye.